The court has also imposed strict constitutional limits on the amount of punitive damages juries can award to punish egregious corporate behavior, most famously in the Exxon Valdez case, where the court cut the award to 10% of what the jury had initially given to those who are harmed by the oil spill off the coast of Alaska. You get the idea. These cases involve a wide variety of different legal claims, and to go through their actual details is quite complex, and there are meritorious arguments in support of many of these decisions, but the practical result, that sort of takeaway, the practical result of all of them taken together has been to protect corporate defendants against lawsuits filed by aggrieved workers, consumers, and shareholders. So again, lots of victories for economic conservatives on the Roberts Court. Still, though, once again, I would not want to overstate the shift. Take the Ledbetter case. This came down last year in May of 2007, and it sparked an immediate congressional response. Congressional Democrats immediately picked up on Ginsburg's dissent, complained about this decision, argued that the court was misinterpreting federal civil rights law as intended by Congress, and in fact, as had long been interpreted by the EEOC and most lower courts as well. And they introduced a bill, the Lilly Ledbetter Fair Pay Act, to reverse it. Earlier this year, it was successfully filibustered by Senate Republicans, but both Obama and Hillary Clinton spoke out in support of it. There's a reasonably strong chance it's going to become law in the coming year under the Obama administration. And in the meantime, the court seems to have backed down from its aggressively conservative reading of federal civil rights law. In the court's most recent term, the term that ended last June, so the term following the Ledbetter decision, by which point this congressional response was already quite clear, the court heard 5 employment discrimination cases, and they sided with the employee plaintiff in all 5 of them. And it's hard to interpret this as anything other than judicial backtracking in the face of congressional criticism. Likewise, the court's record on environmental regulation has been somewhat equivocal. There was one widely noted case adopting a restrictive interpretation of the Clean Water Act, with Scalia's opinion for the court denouncing the enlightened despots. That's a quote of the Environmental Protection Agency. And so the court, again, victory for the Chamber of Commerce, imposing a more restrictive reading on the reach of the Clean Water Act. But this was yet another one of those cases where Kennedy was in the majority but refused to quite go along and wrote his own separate opinion that limited the reach of the conservative holding. And in the court's next major environmental case, Kennedy jumped ship altogether, joining the liberals to reject the administration's argument that EPA lacks authority under the Clean Air Act to regulate automobile emissions in order to address global climate change on this highly salient public issue. In a case where the administration's lawyers aggressively defended the actions of an executive agency, actions that themselves represented a direct expression of clear administration policy, the court rebuked the administration on every front. To take just one example from Justice Stevens' opinion in this case, Massachusetts versus EPA, Stevens noted EPA's argument that climate change raises important foreign policy issues and it is the president's prerogative to address them. Stevens noted that argument and responded that the president does indeed have broad authority in foreign affairs, but that authority does not extend to the refusal to execute domestic laws. And in so holding, Stevens alluded to yet another ongoing constitutional conflict in the Roberts era, one we've already heard some about today from Professor Fisher, and that is regarding the administration's repeated assertions of unilateral executive authority, not just in the wartime context, although particularly in the wartime context, which brings me very briefly to the third Republican constituency, foreign policy conservatives, and what have they gotten from the court? In many ways, they've been even less successful than social and economic conservatives. I've got to give that a caveat. The court tends to get involved with foreign policy only at the margins, right? I mean, the court is not making fundamental decisions that determine the direction of American foreign policy. The court is not going to decide whether the war in Iraq has to stop tomorrow or not. The court gets involved in these issues only at the margins, but where the Roberts Court has gotten involved, it has repeatedly rejected administration arguments that represent one of the central constitutional priorities of this administration. We heard from Professor Fisher this morning about the Hauenstein case, and then we heard at least briefly about the Boumediene case, which was this year's follow-up, in which even where the Republican Congress, pre-2006, even where the fall 2006 Republican Congress supported the president in an effort to create a wholly separate system of military tribunals to try enemy combatants and to deny those enemy combatants appeal to the civilian courts. Supreme Court, with Kennedy's deciding vote, says, no, you can't do that. Right? You can't do that. To sum up, the Roberts Court has, despite President Bush's influential and significantly conservative appointees, John Roberts and Samuel Alito, the Roberts Court has remained willing on occasion, on repeated occasion, to act independently of the administration's wishes, again, in large part due to Justice Kennedy's vote. Still, I think it is fair to say that the court has most of the time been a reliable ally of the governing Republican regime. And from this perspective, the court's role in the political system is just now undergoing an important shift. From here on out, once Obama takes the oath of office on January 20th, from here on out, the court will find itself in a position of opposition to the governing regime. President Obama may make as many as 3 appointments in his first term, but those appointments are very likely to replace sitting liberal justices, right? Stevens, Souter, and Ginsburg are widely rumored as the next to retire. As such, the balance of power on the court will remain more or less the same. With 4 solidly conservative justices and 1 sometime conservative justice, Anthony Kennedy, we can expect this court to throw some significant roadblocks in front of the newly ascendant Democratic regime. Like the 9 old men that FDR confronted in the early 30s, the Roberts Court remains committed to a governing philosophy and coalition that the people have now repudiated. Or to take an earlier example, it potentially remains what newly elected President Thomas Jefferson characterized as the last battery from which the defeated opposition will retire to continue the partisan struggle. If history is any guide, the court will not win this battle. The engine of constitutional change will shift from the court to the White House. Barack Obama has not said a lot about where he'd like to steer this engine of constitutional change, but if the court provokes him, he is likely to embrace the mantle of reconstructive leadership, to challenge the court for misreading our fundamental constitutional commitments, and to call on the people to help him push the court into a new day. Thank you.